Hello, and welcome back to Intellectual Property. My name is Deborah Gonzalez, and I'm going to be your SPU faculty for this session. Today, we're going to be looking at digital technology, games, and the law. There is a handout on your course website, so just you can download it and then follow along with us. As always, we begin with our disclaimer that this presentation is for educational purposes only and should not constitute or be looked at as legal advice. You know, there's so many things happening in technology law and game law beyond intellectual property, so you want to make sure that this is not the only resource you use if you do have a game developer as one of your clients. We're going to be looking at a couple of things in this session. The first one I want to go over are mobile apps and the technology. You've probably heard, oh, there's an app for that, and believe it or not, there is. It's amazing how many apps. Statistics are up to over 1 million app downloads from the App Store for iTunes, and that does not include Android or the BlackBerry apps. But they say, you know, just in healthcare alone, there's over 10,000 apps. So you can imagine how big this market is. I want to look specifically at a healthcare app and some of the issues that are going on in there. We'll look at some of the issues with cloud computing and then SEO, or search engine optimization, and that'll take care of our first part of this session. The second part is really going to be focused on the digital games, video games, social games online, all of those kinds of games that we've been seeing. We'll look at IP protection, we'll look at business models that are happening out there and some of the legal issues related to those business models. We'll look at rights and clearances that video games have to get beyond just what their developers are doing, but for example, music or publicity rights from celebrities. We'll look at privacy in terms of use for these games, and then we're going to finish up with a little discussion on freedom of speech and these games. We did have a case that came through in California last year, and I want to make sure we touch on that before we end our session. Okay, so let's begin with this idea of mobile apps or applications. And the reason why we call them mobile apps is because we're not just looking at the physical games that you can play off your television, but we're really looking at games that are going to be off your cell phone, off your tablet, things that allow you to be mobile. So that's why we're talking about mobile apps, applications. And applications are things that allow you to do many different things, not just games. It could be productivity apps like numbers, or it could be apps to help keep track if you're walking. So Map My Walk would be an example of one, okay? But this session is going to focus in on the games, but most of these issues apply to apps across the board. Okay, so one of the first things when you have a client who is developing an app or a game, one of the most important things is the actual name that they're using for this app. What are they going to call it? Okay, and this is important because the name will relate to certain issues such as the branding and the trademarking in order to increase the value of this particular app. So have the discussion with your clients about how important the name is going to be, one for their app as well as for whatever company umbrella they plan on forming that's going to then distribute the app. So that's very, very important. You know, we had a whole session on trademark. I believe it's session 2 of this course, so you want to go back and take a look at that. But, you know, starting with the name, how important it is, because you want to make sure that the name is going to be distinguishable from everything else that is out there. You also want to make sure that it's not going to infringe somebody else's trademark. You know, it's one thing to talk about, well, making a parody of a trademark or a logo, but that doesn't always work when you're in the app field, so you want to be careful about that. The second issue that we want to talk about is what we call due diligence. You know, it's very important that who's ever going to be developing this app does some competitive research about who else is doing what out there in their particular genre of the app, whether it's healthcare, whether it's a game, and if it's a game, whether it's a social game, whether it's, you know, a zombie game, which seems to be very, very popular, or whether it's going to have to deal with some kind of birds being thrown in the air, okay? It's really important to find out what's out there, And what are people downloading? What are people playing with? What are people seeing as being valuable to them in an app? And a little competitive research can go a long way, because you might even have a client who, even though they want to develop an app, still need to raise some funds to do it. And so whenever they're going to put that proposal together or that business plan together, one of the things they have to do is some of this competitive research to make the case as to why their app will be successful in the marketplace. You know, they estimate that people on average will download the app and view it once, and then that's it. So you have to be careful. That's another reason why there are so many updates to app. I have an iPhone, love it, but the one thing that I don't like is that I always get all these little things in my app saying you need to update, you need to update, you need to update. Now, you know, it might be a little bit of a pain for me, but on the other end, for those developers, it means that they have me going back and looking at the app again because there's a new update and I want to see what's new, okay? So it's also about getting that engagement from the ultimate user of that. The next thing we need to look at is this idea of functionality and claims. And this is very important, you know, when we start talking about when you're trying to market the app and what you have to say about the app. Now, when it comes to the app and technology, it's been very interesting, the claims part of it, because a lot of it has also fallen into the patent area. And we have two issues that I want to bring up. In the UK in July 5th, 2012, Apple actually lost a patent fight for the slide to unlock on the patent. So if any of you have your phone and then you notice when you do that, you have to slide to unlock it, right? Well, they had put in a claim in a London court saying that, you know, that was their patent and that the person who was using it could not use it, and the London court did not agree with them. So they lost that. But in a U.S. court in the end of August, beginning of September, Apple actually won a big victory over Samsung, $1.5 billion in terms of the patent based on the tablet. Okay, and it was on those claims and functionality. So if you're looking at more the patent end of the technology of all these things that we're talking about, you want to make sure you take a look at that case of Apple versus Samsung. Because it was very important. Now, it's not the end of the story, right? Samsung has said that they are going to appeal that case. And, you know, at $1.5 billion, I would probably recommend that they would appeal it too. But it also has a lot of people in the technology field sort of wondering, okay, where is this actually going to go? And how is it going to affect us as we move forward to do technology? Because a lot of technology, right, take a look at the tablets. How many tablets are out there? And on the whole, most of them work pretty much the same, except maybe for their OS system and things like that. So, you know, Samsung is really raising a lot of questions as to, you know, how it infringed and whether the patents that Apple has will limit, you know, competitive marketplace and the competitive market, or whether it is something that can be protected under patent. So we still have to wait and see, but it's something to be on the lookout for. Okay, so you have the link to that Digital Spy article about the slide to unlock feature. And again, that is a European case. The Apple versus Samsung is a US case, okay? So one of the things that I wanted to go over are where sometimes the app and the questions of the app, the legal questions, not necessarily the technology part of the app, but it might have to do with the content part of the app. Now, we've spoken about intellectual property, and that's not where I'm going with this. I'm going with actual liability of the content itself. And this came up in the issues of healthcare apps. As I said, you know, there's been over 10,000 of these healthcare apps out there. But the question has been raised, for example, if a person, and this is a hypothetical, if a person, okay, is seeing another person, needs to give them CPR, goes on their cell phone and picks up, brings up the mobile app of how to do CPR, and they follow it, and the person gets hurt, would the developer of that app be liable for what happened if the person says, well, I was just following the instructions of the app. I didn't know what I was doing. I followed that. Would they then be liable? And so we have, as an example, WebMD, the website issues a disclaimer, right? It says, this tool does not provide medical advice. It is intended for informational purposes only. It is not a substitute for professional medical advice, diagnosis, or treatment. Okay? And the other quote that I want to put out here is that mobile healthcare technology is outpacing FDA regulations, Federal Drug Administration regulations. And so, we have this issue then, well, who is liable? Who's going to be able to review all of this content that are in these healthcare applications and let us know whether they're true, whether they're good, whether they're bad? I mean, if WebMD, one of the biggest websites for people to go and get medical information, is issuing this disclaimer that, you know what, this is just information. This has nothing to do with, actually diagnosis or treatment. It's just information. And so they're limiting their liability there. Are we going to see those kind of things on the healthcare applications as well? Okay, and are they going to hold? The other issue about healthcare apps is that, health standards are different in every country, right? And so, one country might say that it's okay to try and help somebody, and if it didn't work, it didn't work. At least you tried. In another country, they'll say, no, if you try and you fail and you make it worse, you're going to be liable, as in the U.S. And so, we have to wonder about that as we're using these apps. Are these apps specific to particular countries in terms of their standards, or is that something that's going to have to be checked by the global community? So it's interesting to see, right? We also have some privacy laws, some health privacy laws that we need to keep in mind here, because what if these apps start collecting some of the data from all these issues and questions that we've been putting in? If it's personal data, how is it being collected? How is it being used? Who is that information shared with? So there are two health privacy laws to keep in mind with this area. The first one is the 1974, the National Research Act. Okay, we have lots of clinical studies that go on. Some of them are starting to use social media platforms to gather information. Private sites may be password protected, but still using online medium to be able to collect that data. The other one is the 1998 Health Insurance Portability and Accountability Act, or what most of us will know as HIPAA. And so every time you go to see a doctor or you go to the hospital, you'll notice that they give you their HIPAA statement so that you understand what your rights are in terms of your medical data. Okay? Now, very closely attached to that, because we are talking about privacy, let's take a closer look at the issue of privacy. And for us, when we talk about privacy in this realm, we're saying that privacy is a person's right to control access to his or her personal information. Okay, so it's my right to control access, to control who gets to see what medical data there is about me. Okay? Now, usually the cause of action against anything that happens in the privacy sector is what we call an invasion of privacy. And this can encompass workplace monitoring, internet privacy, data collection, and other means of disseminating any kind of private information. So, invasion of privacy, if somebody is taking my private, confidential information and disseminating it in some way. Okay, now keep in mind that, when we look at what information actually gets collected on us from these apps and from these games, the easiest rule to remember is it collects as much information as we give them. Okay, so when they ask for permission to access our information, realize that we are giving them that permission when we click yes, so that then we can go and play that game, or so that we can download that app. Okay, we have given them the permission and consent to collect the information that we give them and then use it in the way that they have outlined in their terms of use. So some things that they collect on us are, for example, our browsing behavior, because maybe on the app might lead us to some information on a particular website and how we access that and what we look at. All that gets collected, okay? Our user preferences, our user credentials, and user credentials includes IDs and passwords that may be collected by a cookie file. Okay, user location, where we happen to be at that moment. There is a GPS on most of our phones, especially if you have a smartphone. Maybe we're using an app like Foursquare, where we're actually going in and letting people know where we are so that we can collect some points to that. So be careful about that. Different ways that the information gets collected. Sometimes it's a survey, sometimes it's registration so that you can actually access or download the app. Sometimes it's what's called a permission allowance, and you'll see this a lot on any app or any game that's played through, for example, Facebook, where they'll say, or you go to a site and they say, well, sign in with your Facebook or sign in with your Twitter, and when you do that, they'll bring up a little dialog box and say permission allowances. The open graph, which is basically this invisible net that collects all of our data out there from all the different sites that we've been going. So don't think just because you put it over here and you didn't put it on this site, it may still be able to get over here as well, okay? The GPS on cell phones, flash cookies, all of those are different ways for them to collect the information. Okay. Now another thing to keep in mind when it comes to privacy is that there are very different standards of privacy in the US and basically the rest of the world. The US is sort of the opt-out unless you tell them do not collect my information or do not use my information in a certain way, marketers are going to use it. Whereas in the UK you have to opt in, which means unless I say use it, they cannot use it. Okay, and we have a little discussion going on right now. France has been trying to pass a law called the right to be forgotten. I'm not even going to attempt to pronounce it in French, but it is there in your handout, where they're sort of moving and encouraging to get an expiration date for data, stating that at a certain point data should just be deleted and eliminated. And of course Google, Yahoo, all of those, Facebook, are saying, you know, that is extremely difficult, if not technologically impossible to do. We can't govern all the information that is out there. Would a technology fix that does put an expiration date and automatically delete it when it's there? I don't know if that would actually work. Considering that there is a lot of data that we don't want to expire, that we do want out there. But it's interesting to see that conversation and that argument happening between the US and the rest of the world. Okay, well now let's put the apps aside for a few minutes, and I want to discuss cloud computing. And it's been sort of a buzzword happening within the last year or so. And cloud computing, first of all, is not new. There has always been at least for 25 years, this option of being able to save data off-site, right? Not necessarily in your computer anymore, not in your location of work, but in a different location so that it can be safeguarded. And here what we're seeing, though, is that now cloud computing, what the conversation has done is it broadened it to be beyond storage, to be the opportunity of not just putting it out there for safekeeping, but also putting it out there so that I can have access to it from all my different devices. Okay, so for example, this year I updated all my technology. I got an Apple MacBook, I got the iPad, and I got the iPhone. And what's wonderful, what I really like and have found to be very effective for me, is that they all sync together through the Apple iCloud. And so, for example, if I take a photo of something with my phone, it comes out on my laptop or it comes out on my tablet. If I write some notes in my tablet, I then have it on my laptop when I go back after the client meeting, okay? So there are different ways that cloud computing is being used today than it was before. Before it was mainly storage, backup, safe place for when I need it in case something terrible happens. Now it's really about being able to access my information wherever I am because it's in one centralized location. Sorry about that. Okay, so some of the things that we need to take a look at with cloud computing, since it's usually done by a third party, another company or organization, is to take a look at what kind of service level agreements that we're going to be signing with them, whether this is a terms of use or terms of service for the website, or whether it's an actual document that we signed or a client signed. We want to make sure what is it that we're signing. And one of the things to always take a look at in those agreements are what we call the termination or suspension of accounts clauses. And this is very important because your client needs to understand if something happens and the account gets closed, what happens to all their data and whether they have access to that data or not. Okay, and that could be really important, especially if they're using it so that, they might have employees in all different branches in all different countries of the world, and then if that account gets suspended or terminated or closed for any reason, all of a sudden their people can't work together, and that might lead to some significant financial losses, or it might be that their clients are going to be very upset. So it's very, very important for them to understand that part of it. Okay, they need to understand in their agreement any intellectual property issues that may come up, as well as trade secret. And this is really, really important, especially if you think of some of the regulated industries that might be using cloud computing, like finance, healthcare, legal firms, pharmaceuticals, medical, doctors' offices. There's a lot of information that needs to be kept confidential, or that's considered proprietary, like in businesses, technology businesses, they might have proprietary information. So you have to make sure that in your service level agreements, you have a clause that talks about trade secrets and that they are required to, safeguard and make sure that there aren't leaks to your data because of faultiness on their side, not on your side. If something happens on your side, it's your problem. But if they're the third company and they, have a leak anywhere, then they can be liable for whatever loss you have because that data has been leaked. So make sure you take a look at that, okay? Okay. Privacy and data security, and this is where we come into things like who has access to the data, how is it authenticated, the person who it is the data encrypted in any way, is there privileged data that is in there? And one of the things that you need to take a look at is the Electronic Privacy Information Center, an FTC complaint about Google's cloud computing services. Now, even though this was back in 2009, Google, the FTC complaint about Google's cloud computing services, because I think it's a good read to understand why the FTC was concerned, but it was specifically about encryption and data being leaked and confidentiality. So I think that's a good one for you to take a look at, okay? Other things to be aware of when it comes to cloud computing: make sure that there's compliance with any federal and state law with that agreement, as well as with any of the standards that that particular company may have to adhere to. Take a look at jurisdiction, the location of where the servers are, where the data is, because that may determine where you can bring a lawsuit against the third party, and whose law will then govern where your data is stored. So if you go back to your service level agreement and see whether they're saying that it's your state that's going to govern, or if it's a different state. If it's a different state, you want to know why that state is going to govern it, and it might just be because that's where the servers are actually housed. So it's something to keep in mind, some little detail that you really need to take a look at, okay? The other thing to understand with your cloud computing provider is how they, what their policy is with third-party access. So things like subpoena, e-discovery, it's very important to know what their rules are. So if a subpoena comes in, or if there's a lawsuit, preservation of evidence is very important. Things of that nature are going to come up. So again, this is another detail that you as the attorney should be aware of, okay? As always, when it comes to this, really accountability is the issue here, okay? So now let's go into search engine optimization. And the idea of search engine optimization, we have all these search engines, right? Google, Yahoo, Ask, Bing, all of these, that basically the idea is that when you put in a query, I'm looking for something, then they are supposed to go and do this search based on an algorithm and bring up some results to you, right? And search engine optimization is just trying to use certain strategies so that your company shows up higher in the results than others, okay? And there was some concern. There is this case, Roger Cleveland Golf Company versus Price. It's a 2010 case. You have it here in your handout, but I just want to read to you, okay? And it talks about how, there are certain metadata in a website, okay? And that when there is this metadata, that it's viewed by the search engine so that they can go and bring up results. And one of the questions is, can you use your competitor's trademark as a keyword in that metadata? Would that be trademark violation? And we have one case that says yes, but we have more that say no. So it's something to take a look at. If your client is using any kind of SEO, make sure that none of the terms are going to violate, that they're more descriptive, right? You can use trademarks in a descriptive way other than just using it for deception or to cause confusion on the part of potential consumers, okay? Because remember, that is the sort of standard for trademark violation, whether it causes confusion on the part of the consumer. So you don't want to go anywhere there, okay? So now that we finished some of those parts with the apps and the technology, right, I want to move on and take a look at these issues of the gaming. And the first thing that we're going to take a look at, whether it's an app or a game, is what happens with the contract and the liability that that contract then gives in, You might be doing a contract for the program developer. You might be doing the contract for the client who's then hiring the program developer. You might be doing a contract for the company that's going to disseminate whatever software there is. But one of the things that you need to keep in mind with liability is when you lay out the programmer's responsibilities and what they are going to do, you also lay out some of what they might be liable for, okay? And here's a quick little list. I thought this was interesting. And this deals specifically just with the programming, okay? A security flaw liability such as malware. And this stems from a case where an employee actually programmed in a particular piece of malware before the finished software was delivered to the client. And because it was not caught by the company who was the programming company was liable for what their employee did. And sometimes it's considered malicious code. Failure to notice during testing. It is standard practice for any programmer and any programming company to test out the software before they just give it to their client. And it's not just testing it once, but testing it over and over quite a number of times to make sure that they have not missed anything, okay? And there's also, you always have what they call the beta release, the alpha release, then the mainstream release, any of these launches. There is a process. It's usually not just launched to everybody. Usually there's a small group and then it gets bigger and bigger and bigger. These pilot phases, for example. So you want to make sure that during that time you have ample criteria and guidelines in there so that then it can be checked and rechecked to make sure that nothing's wrong with the code. Any kind of abbreviated analysis, sometimes these programmers are working under a deadline, and so they decide in order to meet the deadline so they won't be penalized financially, they're just going to cut corners. But if that happens and something is wrong with the code, they are extremely liable. So you want to make sure you go over that with them, okay? So the basics with the contract is that, they have to perform and complete what it is that they said they would do in that contract. And these things of the programming liability are just those extra little details for you to be aware of, okay? So now let's talk about the digital games. And, digital games can be in the forms of, for example, the Wii or the PlayStation, the Nintendo, whether it's the portable models, the big models that connect to the TV, whether it's a console, or whether there are games that are online and streamed. Okay, so we're going to be talking about all different kinds of games in that way. The first thing that you need to talk to your client about is whether the game is an original, a clone, or a fan game. Original meaning nobody else has thought of it, it's completely new to them, it's novel, right? A clone meaning that it's almost the same as another game, or a fan game meaning that it's based on another game. And you have to be careful with the clone and the fan games. Clone games are usually looked very down upon. Fan games may find some fair use, depending on how it's performed, because we get back to those copyright and we're going to see that in a minute, okay? And so this turns into, well, what kind of a game is it, right? What are the game mechanics? What do people have to do in order to play the game? And who else is involved in the development of the game? We had last year a couple of sort of startup innovation sessions for game developers and app developers where they can come and spend a weekend and basically develop a game as a group, and then see what happens, right? See what they get at the end of the weekend, and then they show it at the Sunday night, and there's a competition as to who did the best, and then they can take it from there and decide whether they want to pursue it as an actual game, as an actual business. But in that scenario, raised a lot of questions of, well, can we use NDAs between everybody who's there? And an NDA is a non-disclosure agreement, so that if after this person does not want to continue with us, they won't go and go ahead and do their own version of this game, okay? And there are pros and cons into using an NDA in that kind of environment where it's just meant for everybody to come together and sort of work towards something, okay? The other thing that comes out, if at the end there is something that's feasible, who owns it? Is it everybody in that group, even though one did the programming and everybody else did the design? How is that going to be split in terms of revenue and interest if they form a company? So it's very, very important to find out who else is involved in the development of this particular game or app, okay? Remember that you can't protect ideas, okay? You can only protect something, it can only be copyrighted if it's in a fixed, tangible medium, and that's really, really important. Now I have here in your handout some example clauses from a non-disclosure agreement, okay? And I just want to go through them with you because it might not be good for one of those competitive startup, marathon type of development type of events. But if they are developing it, or if you have a client who has an idea for a game, wants to go to a programming company, this is probably something that they want the programming company to sign off on before they take the job, okay? So simple clauses basically talking about confidentiality, talking about why they disclosed it to that person to begin with, and what that person can do or not do, okay? But look at the first sentence. This is basically trying to be very simple language so that everybody understands it. It is understood and agreed to that the discloser and the recipient would like to exchange certain information that may be considered confidential. To ensure the protection, the parties agree as to follow. Okay? And so I just want to read sort of the little paragraph that talks about what kind of information so that you can see just the breadth of data that could be considered confidential and that may need to be protected. Technical, animation, and business information relating to disclosures, proprietary ideas, patentable ideas, copyrights and or trademarks, existing and or contemplated products and services, software schematics, research and development, production costs, profits and margin information, finances and financial projections, customers, clients, marketing, and current or future business plans and models, regardless of whether such information is designated as confidential information at time of its disclosure. Okay? And then here's another clause. You saw the WETH, right? That was a pretty large, sort of wide variety of information that could be protected. Recipient shall use the confidential information only for the purpose of evaluating potential business and investment relationships with disclosure. Okay? And it also goes on to say that the recipient can then use the information within, share it within his circle in order to make a decision, but that those people would also be held to the confidentiality agreement. There's also another clause that I like to put into NDAs, and that's a clause that basically states if the person is not going to be associated anymore with that particular project, that they're required to delete and destroy any files or materials that is related to the project, okay? And that just gives them an affirmative duty to make sure that they either give you back all the data and materials that they received from you, or that they delete it and no longer have access to it. So that's really important. Also, for example, if they've been given access to an intranet while they were part of the group, that that their passwords get disabled and their ID username as well. So keep that in mind too. Okay, so that was that you can't protect the ideas. Our next issue comes to copyrights and trademarks, and we did a lot of that in our first two sessions. But there's a lot of design and development decisions that need to think about the IP rights, and so things such as the world that the game takes place in, right, and some of the elements that are in that world, the characters that are in the game, the avatars, or what are going to be used by the gamers as they interact with the game are going to be really important. But the other reason why copyrights and trademarks are so important in the gaming industry is that because a lot of it can lead to licensing and merchandising. And so I give you the example of Angry Birds here. It started off as this small little app, and all of a sudden now you see them in everywhere. So we have costumes here in a board game, stuffed animals. I've seen them on cereal. I've seen them on pencils. I've seen them on book bags and lunch pails. I mean, you just see them everywhere, right? Well, that would not be possible if the developers who programmed Angry Birds did not have or own the trademark and the copyrights for these characters and these Angry Birds. So that's another reason why it's so important to talk to your clients about doing their registrations when it's required before it gets launched. Because if it gets big, they can stand to make a lot of money from the licensing alone and not have to worry about how many people have actually downloaded the game or not. Okay. The third question that I have here deals with, well, who is the author, right? And we had talked a little bit about that to make sure you know who it is that's involved with the development and who is going to get credit for it. But we also need to take a look at the issue of work for hire and independent contractors. Because remember the example I gave before, that maybe you have a client who has a wonderful idea for a game, but they don't do any programming, so then they hire a company to do the programming for them. Well, you want to make sure that in that contract it says that this is a work for hire, they are an independent contractor, and that all copyrights are reserved for your client so that they won't have a problem later on when they want to sell this or they want to license it, etc. So it's really important to put it into the contract just what the relationship is, okay? So here are some examples for the work for hire clause that I put in here, and so let me just read you one of them. Upon receipt of final payment as stated above, developer acknowledges that he/she has no right or interest in any copyright to the work or other materials resulting from the services performed under this contract. Developer acknowledges that their work was a work for hire as defined by the United States copyright laws. Developer acknowledges that all copyrights and rights to exploit, use, or reproduce this work now or in the future shall be the intellectual property of the client, and developer shall sign any documentation that may be required in the future to assign such documents, such copyrights to the clients, okay? Now, the other important clause is the independent contractor clause, and I have an example for you here as well. The parties expressly intend and agree that contractor is acting as an independent contractor and not as an employee, affiliate, or agent of the company. This agreement shall not be construed as creating a partnership, joint venture, agency, or employment relationship. Contractor retains sole and absolute discretion, control, and judgment in manner and means of performing the services hereunder. Contractor represents and warrants that contractor holds it, him, herself out as an independent contractor, providing the type of services performed pursuant to this agreement to third party and maintains and will utilize for the services contractor's own tools, resources, and place of business. Okay, now it seems that those clauses may seem a little bit detailed, but it is important because each of those things, like if they use their own tools, who has control over the work, those are all factors to determine whether somebody is an employee or an independent contractor. And you want to make sure in this scenario that they will be seen as an independent contractor by the courts. Okay. Now, another question that comes up with the intellectual property issues with the games is, do you need to register, right? Because we know that copyright is automatic. Trademark is automatic as well. It's at the moment that you use. But both of those, even though they're automatic, if you want to be able to have the force or the legal power behind it, you do have to register them, okay? Some people may say, well, you know, it's really expensive to register, especially trademarks, if you think that they can be up to, you know, $350 or a little bit more per category, and you might need to trademark more than just one category for a particular character or a game. But you do have to look at how much exposure the particular game or app is going to have and what is the value proposition for registering it. So it's discussions that you have with your clients as to whether they want to register it or not. And, you know, if again, that licensing, if they want to license any of those characters or games, they definitely have to have it registered so that they can be protected, okay? Another question that comes up is this idea of sale or license, and rights can be transferred either through a sale or a license agreement, and rights can also be split, right? So you can sell the right to distribute the game without selling the right to necessarily make a derivative work for it. The rights can be limited. It can be only for a certain length of time, or it can only be for a certain territory in regards to that particular game or app. There are some discussions now as to whether if you sell an app online, if it's really a sale or if it's just a sort of a lease or license to use as long as you have that particular item, like the cell phone where you downloaded it or the iPad. You may have heard recently there was a rumor going around that Bruce Willis was going to sue Apple so that he can then, in his will, sort of give his iTunes library to his daughters. According to the Apple iTunes store, you know, that is not transferable. You just can't give people your playlist and stuff like that. And of course, people spend lots of money paying for the songs and downloading the songs, and they're very surprised to hear that they may not necessarily own the songs, that they might just be having it on a license, and once they no longer have that device, they will no longer have access to that music, or if they no longer have access to that particular service. So it's just something to take a look at and to be mindful of, okay? The next thing are business models. Now, one of the issues with games is that for the most part, online games have an audience that's used to paying in order to play. Okay, so if you think of World of Warcraft, Farmville, and even Farmville, even though it's free to play, Farmville does involve certain microtransactions to be able to get some tools to make your play more fun or to advance your level. Gardens of Time is another one, that they have these microtransactions where people can purchase virtual goods Sometimes they might even have advertising or sponsorships in these games. Some branded product placement may be in the games as well. And so it's really important that if your client is making this, amazing world and may have some kind of advertising involved in it or wants to monetize it in any way, that both of you have a conversation about terms of virtual currencies, about how transactions will be monitored and actually how they go through electronic commerce in that way. Whether you have to deal with the interstate commerce laws if you're going to be doing that. Are there sales taxes involved in this? And different jurisdictions might have different responses, such as different countries will have different responses than what's happening here in the U.S. So again, these are things that if you're not familiar with, maybe get to an attorney or a law firm that has done a lot more in this area and see if they'll co-counsel with you. But it is something that your client needs to take a look at seriously, because there are legal consequences to any kind of microtransaction or virtual currency exchange, okay? So keep that in mind with your business models, because one of the things that your client always wants to do is they want to recoup their money, right? They put in a lot of research and development. They want to recoup some of that, so you want to make sure that as they recoup it, they're doing it within the legal guidelines of the law. Okay. Now here's another one that tends to get some game developers into some trouble, and you might see some of these cases come up. It's about publicity and music rights. Now, one of the things is that music sets a tone, sets a mood for the game. It can make it very dramatic at certain points, or it can just set sort of suspense at another point. So it can be very important. Sometimes you have games that are just based on music. So think of, what was it? It's something with Rock Band, for example. Guitar Hero is another one. Those deal specifically with music, versus some that are using music as the background in order to set up the ambience. For both, you need to look at licensing. You need to look at, well, if there's lyrics, there's going to be royalty for the lyrics and compositions. There might be royalty for the sound recording that you're going to be using. If it is something like a rock band or a Guitar Hero, where you also have to take a look at the royalties for being able to have your audience perform the songs. Or even if you're going to use a celebrity or a musician as part of the avatar scenario for that. So we had a very famous case with a certain band, and they had agreed that they could be used as avatars, but only for their songs, not for any other songs. And there was a sort of back door in the game that allowed users, once they knew the code, to use those avatars to play any song. And so that band was able to win that case as a publicity rights case, saying, their rights were only for that music in that part, and now they're being exploited in the other parts, okay? So it's something to keep in mind. We have a lot of cases and controversy coming up on games that deal with NFL athletes, for example, and whether their images can be used without compensating them. Some of the cases have come in that yes, because they've signed off most of their rights to the NFL, and the NFL then has the right to sign it off to the game developers. So there's always been a little controversy there, because the athlete, who it's their image, right, isn't getting the full benefit of their image being used there. Another thing to be careful about with this is any kind of offensive content that may be out there. There is the Children's Online Protection Act, or COPA, that has recently been revised. So if your client has a game that is going to be geared towards children, this is definitely something that you want to be very well acquainted with. Disney ran into trouble with COPA on their Go website, Go Disney website. So again, another important issue to just take a look at. Okay. Our eighth topic that we want to look at in this section is access and distribution, because after you finally develop it, you want to make sure that people have access to it. You want to make sure that people can get it when they want it, okay? And so this is where you start looking at digital rights management and licensing agreements And you also want to start looking at international standards for content. So those ratings, right? Right now the video game industry is self-regulated and they put their own ratings. So if they say NR, if they say, mature audiences only, this is the time when all that comes in, because some countries might actually censor and say, no, this is banned here. So you want to make sure that you take a look at that. The App Store, the Android market, Facebook, all of them will also have their standards of how they will accept one format or another. So you want to make sure you take a look at that. The App Store, you submit so that your app can be there, but the App Store determines when it will actually be launched in the App Store, and they will take a percentage, just like the Android market will take a percentage of the app or the game every time it's downloaded. So that's just, again, another little financial thing that you need to keep track. Now, number 9, and we've spoken about this many times, the issue of privacy. And I cannot emphasize it enough. If you are collecting any data from people so that they can play your game, you need to have a privacy policy. You need to look at your terms of use and your user agreements. And sometimes these are called the end user license agreements. And there was a very funny case, I love it, talks about that one of these end user license agreements on these websites said, if you violate our rules, we have a right to suspend your account. And if you keep violating them, we have a right to call your mother. And so one situation occurred and they called the boy's mother. Now, the court said that was fine and that was not cruel and unusual punishment, because if you look at the market of who's really playing games, it's usually going to be a young male, probably under the age of 25, still living at home with his parents. And so going to the mom seemed a very viable and logical recourse for the court. So there you go. Depending on who your audience is, you might even put that in your end user license agreement that you can talk to their mother. Okay. And then the last issue that I wanted to talk about deals with the freedom of speech concern, the First Amendment rights versus censorship. And in June of 2011, Justice Scalia and the United States Supreme Court brought down a decision, and it's in Brown versus Entertainment Merchants Association. This is originally a California case, went up to the Supreme Court. And the quote is, video games are protected speech, and that restrictions based on their content would be subject to strict scrutiny. So California's ban on violent video games for children was declared unconstitutional. So they couldn't just ban the video games because they thought they were too violent. That was actually up to the parents to determine whether to purchase them or not for their children, but it's a freedom of speech issue because adults should still have the right to have access to it. So this was lauded as a very big victory for the video game industry, and it is an interesting case to sort of read up on, take a look at how they looked at the freedom of speech and protected speech aspects to video games, and specifically violent video games. Okay, so just something for you to take a look at. The last thing that I gave you on the handout is this case that came again from the European Court. This came in July of 2012 of this year, and it said the European Court of Justice ruling digital games can be resold. Now that was a big issue. If you remember, we were talking about the sale versus license issue, okay? And in the U.S., how we're more like we're licensing. If it's completely digital and you didn't get a CD, you didn't get anything, then we're more going to see it as that it's been licensed, whereas in Europe now, they're seeing it as that it's been sold, and you can resell it to somebody as long as you delete it from your own, and it's very important that you do. Okay, so I gave you some resources here. If you're interested in this area of law or you need some additional information to help with your client, in Georgia specifically, there's the Georgia Game Developers Association, GGDA. They have an annual conference called the Siege Conference, and I'm always part of the legal panels that are there. They've also got great development panels. If you just want to learn about the vocabulary and the industry, this is a good conference. And there are many other kinds of game developers associations. So just Google, put your state next to it, and see what comes up, because it is a developing field evolving, and we're going to see more and more of it as we go along. South by Southwest Interactive. Now, South by Southwest, which is held in Austin every year, has 3 tracks: interactive, film, and music. But the interactive track not only deals with things like online websites and social media, but also deals with the video and social gaming industry. So it's a great place to take some, get some CLE that you may need, listen into some of the panels, learn what's going on, big trends. You can also follow them online if you can't get there in Austin, but it's a wonderful experience if you can. There are also the Technology Association of Georgia, and you'll notice that there'll be Technology Association in just about any state. Google them, see what's up, get involved with them. In your particular state, in your bar association, there might be a technology mobile app section. See if they deal with video games. See who else is involved in your bar association of this, so that you can, again, increase your knowledge and let them know that this is an area that you're very interested in and want to pursue. And the last one I'm bringing up is Women in Gamers International. This one is close to my heart, of course, as a woman, but also because there are more and more females getting into this area, and it is new for them. It's basically been a boys' club up to now, but there are a few of us out there, and so it's just good for support, and also to let girls know that this is something that they can, in fact, aspire to, and be a game developer as well as be an attorney that deals in the game industry. Well, I hope you enjoyed this session. It was a lot of fun to talk with you about games. There's so much more out there to learn, so don't stop looking and seeing what else you learn. I'll see you online. Bye-bye.